today's program on the street. On the street is a local program that we interview people to feel how people are doing within the space of Nigeria, and to also bring their voice before policy makers, so that policy makers can understand what the people feel. And so on the street today is myself, the anchor of the program. My name is Dennis Ekwere, the Executive Director of Children and Young People Living for Peace. With me today is our guest, Barrister Emmanuel Ekpeyon. He will be our guest. I will be talking on issues that affects me and you, on the rights and freedom of association. What are your rights? You need to know about it. Stay tuned. We'll be back after this. Welcome back to the program On the Street. On the Street is a local content program that speaks about how ordinary citizens feel on the street, talking about the politics, the economy, the environment, and the rest. So today we have, like I said before, we have our guest in the studio, Barrister Emmanuel Ekpeyon. He will be our guest and will be speaking on issues around freedom of association, what they are and how we should enjoy freedom of association. Talking about myself and you, what rights do you have as a citizen of Nigeria before freedom of association? So with me in the studio is our guest, Emmanuel Ekpeyon, Esquire. You're welcome. Please, can you introduce yourself more to our guests in case they want to know more about you?
Thank you very much for having me on your program. My name is Emmanuel Ekpeyon, Esquire and KSM. I'm very happy to be here. I'm a managing partner of a full-service commercial law firm called Fred Young and Evans, and we are into commercial law practice as well as constitutional law. So what we'll be discussing today is an overlap between commercial law and the freedom of Nigerian citizens as well as the constitutional rights of Nigeria. Now, in the course of doing business and in Nigeria, the CAC, the Corporate Affairs Commission, now passed the Companies and Allied Matters Act 2020. It's a very nice law, very innovative, in which it brought many innovations into the operation of businesses in Nigeria. One of them is the one-man company. One man can actually own a company now in Nigeria, as well as other innovations such as sending notices of meeting by emails and all that. A wonderful law, I may say, in doing business in Nigeria. But in the course of reviewing the law, I now found out that the provisions as it relates to incorporated trustee actually takes away a runs in the face of the Constitution as it relates to the freedom of thought, conscience and religion enshrined in Section 38 of the Constitution, as well as freedom of peaceful assembly and peaceful assembly in Nigeria. So we now found out that now the right, this freedom were enshrined in the Constitution for good reasons. That the state should not, run in the face, should not come into the private affairs of how people exhibit their beliefs and how they actually assemble. For instance, Section 839 of the Constitution provides that of the Companies and Allied Matters Act 2020 provides that the Companies and Allied Matters and the Corporate Affairs Commission can actually apply to court to remove a trustee of an incorporated trustee. This, to my mind, did not go down well with me. Now, the Corporate Affairs Commission is not a member of an association. How will they say that the Corporate Affairs Commission can apply to the court to remove a trustee if it, in its own subjective mind, find out that the association is not being run for the purpose in which it was incorporated, or that the funds of the association is being used fraudulently or for public interest and all that. Now, where is the position of the members of the association? Because most times people exhibit their thought, conscience and religion as well as peaceful assembly by incorporating an incorporated trustee. Now, the CAC is supposed to register this association, and not to the management of the incorporated trustee is supposed to be the sole aim of the members of it. For instance, in a political party, CAC cannot go and remove the chairman of a political party, or INEC cannot remove the political chairman of a political party. Now section 842 of CAMA up to 846 actually provides that the association should file annual returns, biannual returns and all that. Now incorporated trustees are actually different from charities. Incorporated trustees are how people actually manifest their thoughts with members. It is not for business. It is not CAC's business to want to know what happens in the dormant accounts of incorporated trustees, because same does not apply, for instance, to political parties. So to my mind, I see it as a way in which the state, represented by the Corporate Affairs Commission, want to emasculate the rights of people. Because if there is any problem with association, it's supposed to be members of the association that are supposed to go to court for the interpretation of their constitution. So I don't think it is CAC's business to actually interfere in the running of an association. This was what informed our mind that we commenced an action in Emmanuel Ekpeyon Esquire versus the National Assembly as the first defendant, the Corporate Affairs Commission as second defendant, and the Attorney General of the Federation and Minister of Justice as the third defendant, for the court to interpret whether the provisions of those sections does not run in the face of the Constitution, which in its wisdom assured citizens of their freedom of thought, conscience and religion and peaceful assembly. And as an addition to this, section 851 provides for the Administrative Proceedings Committee, which says that matters arising from the Companies and Allied Matters Act should be tried by this committee. Now this runs in the face of section 6 of the Constitution, which provides that the judicial arm of government should be the arm of government that will interpret, and if there is any problem that has to do with any issues, that will have to go to court. Now how would the National Assembly now make the Administrative Proceedings Committee to be at par with the Federal High Court? Section 36 of the Constitution guarantees citizens of Nigeria the right to fair hearing before an impartial judge. Now in the Administrative Proceedings Committee, CAC, 90% of that committee is made up of employees of CAC. CAC most times will be the judge in that case. They will be the accuser in that case. They will be the one to decide the case, and they will be the one to issue fine. You cannot be a judge in your own case. Also section 251E of the Constitution provides that any matters that arise from CAMA or any law that replaces CAMA should go to the Federal High Court. Now section 851 of the Companies and Allied Matters Act now makes the Federal High Court to be a court of appeal on Companies and Allied Matters Act. And section 1 subsection 3 of the Constitution provides that any provisions that run in the face of the Constitution is null and void to the extent of its inconsistency. This was what operated in our minds when we now commenced that action before Justice Omotoso of the Federal High Court, Abuja Division. And the court agreed with us. The court agreed with us that over-regulating associations in the way the Federal High Court, the Companies and Allied Matters Act is doing, that gives so much powers to Corporate Affairs Commission, which is an agency of the federal government, will filter the ability, the liberty of association. It will be an encumbrance. It will be an encumbrance to Nigerian citizens to actually practice their religion, because CAC is now made by the law to be a part of associations in Nigeria. This to our mind will not work. It will not work. It is a recipe for disaster. For CAC being an arm of government to be made to run associations, I think this to our mind, because INEC do not run political parties. INEC do not run political parties. Even if their internal rancor in a political party, the parties will go to court for the court to determine the rights and obligations of each member. INEC is not made to decide who will come as a chairman, or how they run their affairs, or how much their funds will be, and all that. That is an internal affairs of the political party. So why would the citizen, the rights of the citizen, they are eliminated like this because maybe the citizens, nobody stand out for the citizens. That's why the National Assembly, which is an arm of, of government, will actually make a law to actually take these rights away from the Nigerian citizen. So Justice Demotation in his judgment in April 2003 actually agreed with us that those sections that run in the face of the Constitution is capable of taking away these rights. The main wordings of those sections run in the face of the Constitution. As such, those sections were struck out. Well, after some time, CAC appealed to the Supreme Court, and the matter is presently at the Court of Appeal, and all the parties have filed their briefs, and we are waiting for a hearing date.
Yes, you've spoken so well that I've learned anything, and I just believe that my audience too can learn and they are catching up so that we can actually know what our rights are. First of all, I want to appreciate what you just said, that you cannot be a judge on your matter, and it simply gives me an idea that you cannot be the umpire, the referee, and then you're a player in the field. Absolutely, you cannot. And then let's run the last one for today. Just one question for you, so we can take it home. I want to know the importance of that judgment. How important is it, given that non-governmental organization, especially where I belong to, is part of incorporated trustees, and they are also registered as an association. What does that judgment actually mean to non-governmental organization, and how can they, leverage on that judgment? Is there any hope? Are there windows of opportunities? What are the windows, Eddie? You can let us know.
Thank you for your question. Fortunately or unfortunately, incorporated trustees covers churches and religious places, mosques in Nigeria are registered as incorporated trustees. This also includes non-governmental organizations as well as charities. Now, the main idea that CAC tried to put forward why they made this law is to be able to monitor money laundering and other financial crimes. But Nigeria has a law, a very detailed law on money laundering. Nigeria have laws on criminal misappropriation and all that. So if, for instance, the state or the EFCC finds out that in the account of any association there are actually dubious money inside, they can actually go after it and see how to hold the people doing the money laundering within the association and hold them responsible. But that does not give them the umbrella right, let me use that word, to determine that because some associations are used as a platform for fraud, to want to regulate every association. You can't throw away the bathwater with the baby. Because the whole essence of having associations to profess one's thought, conscience, and religion, and to peacefully assemble with people of like mind, will be taken away if CAC as a third party is made part of that association. So maybe as time goes on, there should be a different law for charities, so that the state can hold, trustees of charity responsible. But this should not apply to non-governmental organizations as well as religious place of worship, because this is the way, to some extent, in which people ventilate what they feel about maybe the government of the day, and the non-governmental organization to a large extent hold the government responsible. So this will be a way to filter the powers of the non-governmental organization, to my mind. So this law, to some extent, is a kind of freedom to non-governmental organizations, to the extent that the accounts of non-governmental organizations And the running of non-governmental organization should not be the problem of CAC or the government. If they are found to have committed a crime, that is left for EFCC and ICPC and other criminal bodies to hold, but not to determine how it is run. How it is run should be the problem of the trustees and the members of the association. So as it stands now, the effect of that judgment is that CAC do not have the powers to remove a trustee of a non-governmental organization or a religious place of worship or a charity as it stands now until the judgment is set aside. CAC do not have the power also to interfere in the accounts or dormant accounts of the associations. Also, the provisions of section 851, which constitutes the administrative proceedings committee as a court, which makes CAC the umpire, the judge, the prosecutor, and the punisher, is not applicable as it stands now. So those provisions of the Companies and Allied Matters Act from those sections that we challenge in court has been struck down. So in the eyes of the law, they are not in the provisions of the Companies and Allied Matters Act until a court, the Superior Court of Records, actually say otherwise. So as I said earlier, the matter is before the Court of Appeal, in which briefs have been filed. Now we are waiting for a hearing date to hear it. And this case will be a very fundamental one for the Nigerian people, because it will determine the extent of the control in which the Nigerian state should have on the freedoms of the Nigerian people. And to a large extent, the court, which is the last hope of the common man, is most likely to determine it in favor of the Nigerian people. This is our belief. So we will see that we follow up this case to logical conclusion and also create awareness, because some of these laws that we have in Nigeria, most of, for instance, associations such as civil society groups, who take care of its members as well as protect the rights of the Nigerian people, do not know of some of these laws and its effects on the Nigerian people. I was shocked that even when the law was made, non-governmental organizations do not even do anything about it. And there is no how those sections will be operated, but it will not take away. At the end of the day, there may not be any non-governmental organization, because the power given to the Corporate Affairs Commission is subjective. It is when they determine that is against public policy, they are applied to court. What is their business about the running of association? Now, money gotten mostly for association, non-governmental organization, religious and bodies, are contributed by members. Most of them, they are widows' might. Why do the Companies and Corporate Affairs Commission want to regulate them? Because they are not public funds. If public funds are traced there and it is criminally obtained, let the law take its course. But for you to say every association, GSA will need its main mandate of running commercial businesses to ensure that the investors' funds are protected. Instead of doing that, they want to now come and be regulating association that is for the welfare of the Nigerian people. I think this is too much power given to the Corporate Affairs Commission, which is, to my mind, totally out of place and which will cause too much rancor in the Nigerian society. And I think it should not be. Thank you very much.
Yes, we've heard it all, and that's why we had him as a guest. He has not disappointed us. He has spoken our mind. He has spoken our voice. As ordinary citizens, he has spoken what we ought to have spoken to the policymakers, to our government of the people, by the people, and for the people. That's just what government is all about. And so for today, we are about drawing the curtains. And one thing left is a challenge. There is a civil space, civil service space. The space is getting shrunk every day, and part of it is what we just discussed. And the judgment has expanded, opening up the civic space, and that's why we celebrate him for that boldness and for that effrontery. So on this note, I want to tell you thank you and urge you to watch our videos, like, share,